The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason. Bears, squirrels, protection from burglars, or zombies makes no difference.
That opening line, bears, squirrels, burglars, or zombies, almost sounds funny, but it's not. It's sarcasm with a purpose. The judge is furious that this man is pretending there's any justification for having weapons as a convicted felon. This isn't about hunting or protection. It's about accountability and blatant lawlessness.
This was a very difficult decision to make. I have in front of me allegations of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided.
You can hear it in her voice. This wasn't easy. She's facing a plea deal in a case involving deeply traumatic harm to both an adult and a child. This isn't just paperwork. She's carrying the moral weight of the entire courtroom.
It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoint from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of.
This part might sound legalistic, but it's one of the most important. Judges aren't just there to rubber stamp what prosecutors suggest. Their duty is to protect the public. If a deal doesn't serve justice or safety, they're obligated to stop it, even if everyone else agrees. That's rare courage.
Be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law and its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. Utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remain. The defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He does not legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden wakening.
Skepticism and trepidation. Serious judicial language that signals something about this deal feels off. When a judge hesitates this strongly, it's often because she senses injustice hiding in plain sight.
And worst of all, he unlawfully keeps a loaded firearm next to his bed, and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each, charged account or any associated subsequent or lesser offense, that would be one thing.
This part is terrifying. Loaded weapons scattered around the house, binge drinking, untreated PTSD, and waking up in violent states. And he's fully aware of it. This man wasn't just dangerous, he was a ticking time bomb. And yet, this plea would hand him a reduced sentence.
With this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be as the party degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are
7 felonies gone just like that. This isn't about mercy. It's about minimizing. And when courts minimize violence, the message to victims and the public is clear. We'll look the other way if it's convenient. That's exactly why the judge is pushing back so hard.
And the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law. If the court further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law. And the entire—
She's right. This case is that serious. Accepting the deal would cheapen the pain, the trauma, and the law itself. Worse, it would reward recklessness and show complete disregard for everything the justice system is meant to protect.
Case is not opposed to a trial, even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim. It is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges.
This line hit me hard. The plea isn't about sparing the victim. It's about sparing the defendant, and that's not how justice should work. If the victim is willing to relive their trauma in trial just to ensure this man is held fully accountable, that says everything.
Decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9 they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 whenever we set it. We're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
No compromise, no sugarcoating. The judge ended the hearing with authority, sending the case to trial. And honestly, thank God for judges like her, because sometimes the only way to truly honor a victim's pain is to stand up and say, "We fight this all the way."